Everyone, this is Don Collins. I know most of you. I see some of the folks logging on, old friends, old professional colleagues. Welcome. Today's presentation, in my mind, is one of the more astute, one of the more timely presentations, topics we've dealt with in a while. I know we've always talked about the pandemic, and we're all hoping it's going to go away and subside. But at the same time, while it's we believe going away, we still have the issue of employee relations. And one of the issues that I see, and I've been on several Zoom meetings recently where they've talked about it, is the idea of worker shortages, what employers are doing about that, including in the public sector. Now, today's presenters are two preeminent practitioners in the field of labor relations in the state of Ohio, and they'll be addressing what they're seeing out in the field in terms of collective bargaining and labor relations. And I'm looking forward to the presentation this morning. The first presenter is Steve Lazarus. Stephen is a union side lawyer representing primarily public safety unions in Ohio, but not all, and has a well-deserved reputation as being an able representative throughout the state, looking out for the interests of various unions. The other individual, I'm not sure I've seen him before, but his name is Johnathan Downs. Likewise, he's been around very successfully helping management side folks deal with and navigate through collective bargaining and labor relations. The way it's going to work this morning is Steve's going to go first. He'll make some remarks. Johnathan will come in later. And at that point in time, hopefully we'll get some discussion going. We would ask that you, if you have questions, you can raise your hand and voice your questions on Zoom. Also, you can use the chat box as well. So please take advantage of this. These are two of the experts. And if you have any questions, now's the time to ask it. Learn something, take it back to work, and tell your boss, and they'll think you're a hero. So for everybody's edification, today we've had one of the larger groups of attendees. We have 50 registered, which is more than we've seen in a while. So with that, I'm going to turn this over to Steve. Steve, take it away. Thank you.
Thanks, Don, and thanks to Colera for having this. It's been an interesting issue here last year and a half with COVID, and it really has had huge impacts on virtually everything we do. From the advent of Zoom and other platforms for negotiations and for mediations, arbitrations, and that has, I think, had some good and maybe some negative effects. Obviously, as an attorney and our practice, our firm, we're in Kentucky, we're all over Ohio. And I think the Zoom has certainly made it more conducive to long-term relationships with unions on my side, where you can have meetings that you don't have to drive to Cuyahoga County or to, wherever from Hamilton County where I am. So that's opened up a lot more possibilities as an attorney, but it's also, I think, led to some challenges as far as some interpersonal relations. We talked about some of these larger negotiations that we've done where you've got, 10 plus people on both sides of the table. And, my experience in negotiations is always trying to read the people on the table, read the people who are on my side of the table, read the people on the other side of the table. And it's very difficult to do that when you're trying to look at all these little squares, and they're not that easy to see, and you can't kind of see the body language and some of the other things. So I do think there is something that's lost. There's something that's gained through this. I don't think it's going away. But I think you probably see more of the live negotiations, live arbitrations. My clients are generally preferring to have like an arbitration hearing, particularly on a disciplinary issue. I think preferring to have something live as opposed to a Zoom because, you know, they just feel like they're more involved and at the hearing. So moving on to more specifics to, you know, what's going on with the actual mandates and vaccines and so forth. There's been very little actual forced mandate vaccines. However, very recently, we do represent some state employees, and I know there are several state DAS, OCB people involved in the call here as well. But there are some mandates that have come down that were just upheld in federal court for people who work in hospitals. And there's some strict time schedules on percentages of those people that have to be vaccinated per facility. And that's ongoing now. There are religious and medical exemptions that apply. And I think the medical is probably a little clearer, but the religious exemption is an area that I think is going to see some interesting applications here in the next several months. We've already seen some of it. I think there's some skepticism that maybe is thought of when people have religious exemptions. I'll tell you of one person I was involved with in the last several months who wanted a religious exemption, and she told me about her situation, which included never being vaccinated herself since she was an adult, that she had 2 children who were now both teenagers. They were never vaccinated. She had to, for years, send in special exemption paperwork to their schools. She's gone through 3 pediatricians as they grew up, who would throw them out of their practices because she refused vaccinations. And, you know, not surprisingly, she got an exemption. And I think this is probably the clearest case of that I've seen. I've seen a good number of them, and most of them have been accepted. But that to me was someone that really lived this their whole life. So other than that, what I think we're seeing a lot of are these hybrid kind of situations where if you get the vaccine, you have certain things that you have to do. If you don't get the vaccine, you may have more things that you have to do. And I'm getting a lot of blowback from employees on this, because what we found is that whether you have the vaccine or not, you can get COVID. And I'm not sure the instances of getting it are much different whether you've been vaccinated or not. So we've got a lot of people who are not vaccinated, who are unhappy with being treated somehow in some ways differently than people who have been vaccinated. One jurisdiction has gone so far actually as to provide administrative leave for people who are vaccinated and who either get COVID or have to quarantine because of COVID. Whereas if you're not vaccinated, you don't get that administrative leave, and you have to burn your sick leave or other leaves if you have to take time off. And that's, again, creating a lot of dissension among the ranks. But so far, I think employers that I've dealt with who are trying to develop a COVID policy have been willing to negotiate with the unions over that policy. However, they have not been willing to negotiate to impasse. I've been involved in several unfair labor practices at CERB. Those have been unsuccessful to date on behalf of the unions. But basically the issue there that I think people are looking at are whether this is a mandatory subject to bargaining, and if so, is there a requirement to bargain to impasse? To date, again, CERB has not taken that issue in favor of the unions. So that's out there. There are also some grievances that are filed on this issue. I've got several of them that relate to sick leave and whether one is sick leave something that the employer can mandate the employees to take? Obviously, all these grievances depend largely on how the contracts are written. If the contract is pretty restrictive on the fact that it's the employee's right to use sick leave, and the employer is requiring them to use that sick leave, there may be an issue there. I've got one contract that talks about how the employer is required to negotiate with the union over any new types of disciplinary action. And the argument from that union is that by requiring these employees to use sick leave or vacation or other types of leave when they have to quarantine, that's a new form of discipline. It's taking away their ability to have just cause protections from the taking of their leaves. These cases have not been arbitrated yet, but these are out there, and there's going to be some finality to those as we go forward. These are some of the things that I'm dealing with, and it's interesting because as a union advocate, I'm really getting it from both ends on this issue. I've got some people that are extremely anti-vaccine, who are trying to push the union in that direction. Then I've got, in the same unions, I've got people who are extremely pro-vaccine and believe that this is a public safety issue that we've got to get. We've got to fight to make sure people are vaccinated. And the approach I've taken when I am on the phone with either of these people who have very strong feelings is I make clear to them that I have no opinion on the issue, and that I see merit in both sides of this, because I'm not interested in getting into this issue, which is frankly just become very, very political. Those are some of the things that I'm dealing with. I think that I've seen a reluctance on the part of management, particularly as it relates to public safety, to implement any sort of mandates because of the concern in the current environment, where it's very challenging to find police officers and firefighters to take jobs, to stay at their employment, to not go elsewhere for higher pay. That I think there is a reluctance to apply a mandate because there are some people who would quit and go elsewhere. That's how strongly they feel about it. Other issues, the only one I would probably bring up in the state, and there is language in the state labor agreements relating to emergency pay. And all those state people are on the call, put your pens down. I'm not going to get into details on this at all, but there are arbitrations that are ongoing because if certain conditions are met, then there's an $8 supplement that would be paid for all hours worked during a state of emergency. And so that's an issue to watch because those arbitrations, the first one is ongoing as we speak right now. So I think that's the kind of the basics of this. I love to get into question and answer from people. And I think I'm on a cell phone, so I see people trying to get in on a chat. So I'm gonna have those kind of brought up by either the moderator or by Johnathan as we go, because I have trouble monitoring those on my phone. So thank you all, and I'll open it up to questions or Johnathan at this point. Thanks.
Well, good afternoon, everybody, or good morning still. I think, Don, I am not seeing the chat function on my screen anymore. So I know the chat was being used for people to record their Supreme Court number. So if you have questions that are coming up for either Steve or myself, if you would just bring those up live, real time, I think we can handle those in a real time sense as well. So I'm going to echo a number of the points that Steve made, and I'm going to go down a little bit different path as well. First of all, the COVID with remote negotiations, arbitrations, meetings, et cetera, has made improvements in some areas and has made it challenging in others. As I mentioned earlier, Steve and I negotiated one of the state contracts with the DAS OCB team, as well as the team that Steve brought to the table. It was quite an experience. We got to see tours of people's homes as they were walking around with their camera. We got stories behind that as well. I have found that there are benefits as well to becoming a bit more digital to this process. So that's been good as well. Arbitrations, I will agree with Steve. Arbitrations for disciplinary matters, management also wants those in person. Arbitrators have been very, very collaborative with parties on how we conduct those. The ability to have them with social distancing, et cetera, has not been a challenge in my world. We have held several arbitrations on contract interpretation virtually. We have found those to move along in a fairly good fashion. We have not, as a firm, we have not done any fact findings or conciliations by Zoom or by virtual means, other than the state contract where there was mediation with a couple of the bargaining units, but one of the bargaining units, the last one that negotiated, everything was back in person, and that was late in the year. So I think the impasse proceedings are going to gravitate back to in person and remain there beyond. The social issues that Steve touched on, those who are on either side of the camp or in no camp whatsoever, create an HR issue for you functionally on the ground level. And we see that in private sector and public sector. Now, Steve and I both have a primary practice in the public sector. Our firm does a lot of private sector work as well. And so the issue on the floor, so to speak, or in the workplace is it's pretty vibrant. I'm trying to think of a better word than that, but there's a lot of discussion ongoing, a lot of concerns. You just need to pick up the newspapers and look at what the school boards are going through right now. We're seeing in Central Ohio, for instance, in this morning's news, that 3 of the major school systems in Central Ohio, are dropping the mask mandate, strongly encouraging and so forth. So we're seeing a tremendous amount of change there. We saw the protests at the bridges and the cross-border points into Canada. So it's going to remain a social issue for quite some time. It's been politicized by everybody in one way or another, and that's what it's going to be. ULP, Steve talked about it. Absolutely, I agree that it's a mandatory topic of bargaining, depending on what the impact or the effect of it is. Grievances have come up in more than just the emergency pay area, but again, the issue that Steve raised, which is whether or not, if you're required to quarantine, if that's going to be required to be paid for by the employer in addition to the sick leave accumulation, or it's to be covered by the sick leave accumulations. And there are schools of thought on that. That's the most common grievance I'm seeing coming up now. Emergency pay grievances are coming to hearings. We had one last year, late last year. So those are still working their way through the process and the procedure. I'm not seeing those in private sector cases. We track the private sector arbitrations and litigation in this area as well. I'm not seeing the emergency pay issue there. What we are seeing out of the private sector is more along the lines of safe working environment, OSHA related issues. So those of you who follow the OSHA standards and knowing that the feds don't apply to us, we have our own state agency. We don't know if they'll follow what OSHA is doing. OSHA has run into a stone wall with the Supreme Court decisions there. So I think the safe working environment issues are going to continue. I think it's going to be more driven by employees feeling comfortable at work than it will be by OSHA enforcing regulations. So I see that more as an HR rather than the legal issue coming forward. So let me move to a couple of other topics here. I just wanted to tell you where I see a couple of nuanced difference from what Steve talked about. Oh, back up one point. We have had a couple instances where COVID leave or pandemic leave has been proposed in negotiations as an additional leaves. I will leave each of those situations alone in terms of where they are, but we are seeing that come up periodically in contract negotiations. Since we're still in the general time frame of a 3-year contract expiration, I expect we will see those proposals coming forward from unions in both safety services and non-safety or safety forces as well as service forces coming up as an issue in terms of granting more leave. And the build on that comes from the FFCRA ESL. You got all that right? Got those acronyms down pat, I hope. But the additional 80 hours that Congress granted almost 2 years ago, at which point in time they also did not extend that to safety forces. So the theory behind it is it was granted once, it's for a pandemic, it should be granted again. Then we get into the granular question of what does it cover, if it covers, and also looking at the amount of sick leave that people have are able to accumulate under state law or collective bargaining agreements. What is appearing on the horizon, actually it's here now, and I think that's going to be a long horizon, is issues about COVID and a disability. For instance, in Columbus Media Market, the health department is already doing advertisements to encourage people to receive their vaccines by highlighting people who are suffering from long COVID. So is long COVID covered by sick leave? Well, gets back to your policies and procedures. Is it covered by your injury leave? Can they establish that? Can an employee establish that it was contracted at work? Is it a workers' comp claim? Again, is it connected to work? So the long COVID issue on the initial point is going to address issues such as sick leave and then workers' compensation. But downstream, we see it coming more along the lines of an EEOC claim or disability. So is it going to be? Well, it's pretty much to me an analogous to emphysema, black lung, and others. Is it a disability? Well, limited lung capacity, limited pulmonary capacity is clearly a disability. I don't think there's going to be any difference drawn between COVID impacted versus emphysema versus black lung. I think the standard of the test is already there. This is simply another application. But what I think you're going to see is the expansion of that. And we're going to have to view it medically as well as a pragmatic sense. So EEOC has already indicated, I'm checking my notes here, that the traditional ADA analysis is there. And so if you have someone that presents themselves with a disability as an employer, you have the interactive process to go through. And as David Fram, who's a national speaker on this topic of ADA, says, the question that you should always be asking is, how can I help you? So you have to go through the interactive process. It's there, it's going to be there. In some areas, Steve, especially I think in the area of safety forces and firefighters, the long COVID and the pulmonary issues is going to have a potential more direct impact on the ability of a firefighter to go through there. There are a lot of federal orders out there on contractors, federal contractors. That is not something that we are looking at for you, but I will point to you, watch what the OSHA is doing on its standards, because again, we don't know what the state's going to do on that yet, but we believe that the OSHA is already signaling to us that they're going to develop new rules post Supreme Court decisions, and we'll go from there. Whether or not the state will follow again is going to be theirs. So disability accommodations, Steve touched on the two that are out there, medical and religious. Medical, you're going to have to follow the science on that, the science of the day. We know the science is changing rapidly in this area. There's a lot of phenomenal research coming out. I'm really anxious to see how much more it develops. I think the research out there has been phenomenal. But let me give you a couple of examples of grounds for an exemption under disability And this would work for the medical side, whether or not the person has the anxiety. So is it a psychological disability? Obviously, if there's anxiety, which keeps them from being able to perform the essential functions, then they're not able to do the work. But is there an accommodation? Right off the bat, and I'll come to it later, is the anxiety which leads to coming to work and being around others who the person thinks may have COVID. And so therefore, the person's accommodation may be remote work. Allergic reactions to particular vaccine ingredients. And then what an issue that's still being debated among doctors is whether or not vaccination has a negative impact, potential long-term effect on pregnancy or breastfeeding. In fact, my wife, who likes to watch the medical serials, there was an episode in one of them last week that I just walking through the dining room or the kitchen, watching her watch that particular show. It was about a pregnant woman who refused blood from someone who had been vaccinated. She gave birth to the child, but the mother died, and so you have it. You now have this in real time on medias as well. The religious accommodations, Steve spoke to that one as well. Let me give you a little bit granular on that. The EEOC has a long-standing test on what are the religious exemptions. And if you're going to get into the questioning about the religious exemptions, please, if you don't already know what the standards are under EEOC and what is permitted and what is not permitted in Q&A with respect to religious exemptions, be sure you brush up on that, because there's a lot there, and you could step over the line very, very quickly on that. The burden is on you, the employer. Employers should ordinarily assume an employee's request is based on a sincerely held religious belief. If there is an objective basis for questioning the religious nature, the employer is justified in seeking additional supporting information. That's a quote from the EEOC guidelines. So it's your burden if they give you a request based on a sincerely held religious belief. Now, how do we get to sincerely held? Steve walked through a scenario where I will venture to say that person has the belief, has a documentation. Certain things that you look for is whether or not the sincerely held belief is something that's cut and pasted from the internet. That there are multiple employees submitting essentially the same form, and that the reasons are somewhat inconsistent internally. So look at them before you start asking questions. We strongly recommend that there should be a face-to-face dialogue when you're going into the question about religious exemptions. If you're trying to do it over the internet, you're going to get the answer that you're going to get, which is more cut and paste from the internet. That being said, there's, as I said earlier, there's longstanding law, the EEOC guidance on what is an appropriate inquiry by an employer for what is a sincerely held religious belief. Now, and I think that Steve touched on those before. You know, are there the family members that have had vaccines? Do you take Tums, ibuprofen? Do you describe your body as a temple? Of course, Steve and I describe our bodies respectively as a temple, right? And the documentation from there. Let me shift to the last area that I want to address for only a moment or so, which is going to be remote work. Now, in Steve's world, because he represents primarily police and fire, remote work is not the kind of thing you're going to see, nor did we see it during the pandemic. The state, I know we got OCB people on here, by the more than 10,000, 15,000. So thousands of people working remotely for the state. We're seeing this with private sector employers as well, which begins to tick off a whole series of questions. First of all, and there are pending grievances on this at multiple levels, private and public sector, who pays for the internet? Who pays for the computer? Who pays for the chair? Who pays for the workers' compensation claim if I trip over the cat on my way from the dining room to the den to go remote working? So there's a whole series of things. The SHRM website, for those of you who are SHRM members, has a pretty vibrant agreement regarding remote work. It's almost like an independent contractor arrangement. This has been around for a long time with respect to tech firms that have had people working remotely, developing code and other things for many, many years. Then you get in the public sector, more than that, you get into the accountability question. How do I account for the time? How do I account for sick leave? How do I account for personal? How do I account for vacation? Am I allowed to work different hours because now I can take care of the kids, get them on and off the bus, come back to work, and then go back to work in the evenings to fill out my hourly requirement or the amount of time that I work. But that's an operational issue that many of you are facing. What we're seeing is the grievances that are being filed asking to be on or remain on remote work. The flip side of it is, what does the ADA say about this? Well, the ADA already has a couple cases, and out of the Sixth Circuit, there's one involving the Ford Motor Company, the other one involving Nashville and the name of the county around Nashville in Tennessee. One was a lawyer who was working remotely during the latter stages of her pregnancy, and it was held there that her work did not require her to be in the offices for that period of time. So remote work was an accommodation under the PDA, Pregnancy Disability Act, in the same that ADA would accommodate remote work for a person with a disability. So that's the first hurdle they have to overcome. The case in the Ford Motor Company was the sales staff person who had to be working remotely a lot of the time, but was also required to come to the office and to meet with other sales staff folk. And the Sixth Circuit Court of Appeals there said remote work was not a reasonable accommodation because of the need for the interrelationship. So remote work requests to accommodate a disability go through the same standards of the ADA, the interactive process, and those magic words under the ADA, the essential functions. What are the essential functions? So the key criteria there for you has not changed. The mechanics of doing remote work is one thing. Whether or not you can require them to return to work on site, or you must accommodate a request for a reasonable accommodation due to a disability. The first question is there a disability? Second question is, if so, then what is the reasonable accommodation that's being requested? And then is it an accommodation? Last but not least, because we can get into more granular on those sorts of questions under the remote work, is that nagging issue called the Fair Labor Standards Act. Now, for those of you who speak English and you also speak FLSA, you are multilingual. If you speak English and you speak FLSA and you speak firefighter math, then you are multilingual at the best. And so Steve's smiling because he knows there's nothing more fun than to talk about firefighter math and FLSA together. With that, I'm going to conclude on my opening comments because I've touched on the topics. There's a series of Q&As that need to go through if you're doing remote work. Don, we're coming back to you and inviting questions and opening up. And I don't know if Steve had more that he wanted to throw in there based on my comments, because Steve and I have done a lot of this point counterpoint before, and we respect each other's positions on issues as well. So Steve and Don.
Let me, John, you ripped the scab off a wound here when you're talking about the FLSA. Early in my career, when I was working for the state, we did have a issue with the FLSA. People were working at home and not getting compensated for it. And the judge in federal court, at this time was Graham, disagreed with the state position. That was very expensive. So working at home is an issue that's been with us for a while. And I urge people to, pay attention to it. My question, though, is what is the sense of employers? Are they, do they want people to work at home? Do they want them to come back in? Or are you getting any sense of that? What are you running into? And again, I know public safety, it's not really amenable to them, but how about, office workers? Are you getting pushback or employers saying, no, we want to get them back here as soon as possible? What are you running into?
On my side, with the management folks, it's a mixed bag, but it mostly leans to getting everybody back to work. I know the state has to work more on what the governor says, but on the local levels, the city and the county office workers, it's come back to work. And in some situations, it was they only left for about the first 4 to 6 weeks. And then since then, what they've done in the local level is to, allay the issues and concerns about the workers by limiting public access and so forth. So I would say in the 90s%, Don, it's, we need you here at work. There are some exceptions to that. There are some folks that have been able to continue working remotely. What I am also finding, though, is a hybrid, 1-2 days a week, stay home and work. We've been doing the hybrid here at the law firm since ground zero. Scott DeHart's working from home today. Well, part of that has to do with, he was sick yesterday and decided I can get more work done there. So there's a lot of this trusting on the professional level, but the flip side of it is the accountability question. And that's where the FLSA comes in. Tremendous oversight on that one.
Yeah. Other issue, and I don't know if either of you running into it, but it's come up several times with me lately. And that's the issue of worker shortage. Steve alluded to, police and fire, wanting to switch jobs. And, my understanding is that's a real thing. And employers are trying to deal with that. My understanding is by providing financial incentives, raise the entry-level pay and whatnot. Any commentary from either one of you on that?
Yeah, I think that's true. Johnathan was talking about the remote work, and all the people we work with had to be at work through the pandemic, and I think there is a sense of we had to be here while most of the other workers for city, county, state agencies were able to be at home. And not only had to be at work, but obviously had to be out interacting with the public and potentially getting COVID and so forth. So, that becomes a compensation issue as well of, we're putting ourselves in this position and now after we get COVID, then we're being told, well, you have to burn your own leaves while you have to stay home. And I have seen a little bit with Johnathan mentioned about putting in contracts about, COVID leave and so forth, but probably a more effective contract proposal on the union side that I've dealt with is to put COVID or quarantine as as one of the other exclusions from bonuses that you get. So a lot of contracts will say if you don't use sick leave for 3 months, then you get a personal day, we'll say. And some of those contracts already have exclusions that say if you use sick leave for death of a family member, we're not going to count that against your 3 months of non-sick leave usage. And so I'm seeing some negotiations now where people are putting in there that you still would be entitled to these bonuses if you used sick leave for quarantine or COVID related issues. So and I haven't gotten a lot of pushback from employers on that issue, but one of the big challenges through this whole last year and a half has really been how the rules of the game keep changing. That well, now you have to quarantine for this amount of time, and well, you have to wear a mask, or or you can come to work if you're vaccinated, but if you're not, you have to do this, and that's now 7 days and 5 days, and I think that's led to a lot of frustration and probably helped or fed into some of the people who are opposed to COVID regulations to say, the rules keep changing here, and that's frustrating for everybody. I understand why it happens. This isn't some nefarious plot, but as the scientific information gets better, the rules continue to change. But that is it doesn't make it easy for those that want to say, well, you have to follow the rules. So,
Don, let me throw out one more point that I failed to mention, and Steve's point about grievances. They're more coming from the last rise in cases in the last year. So early on, we didn't see a lot of grievances. Almost for the first year, we didn't see grievances about being on leave or whatever. But that begs the question of FMLA, which I apologize for not hitting on that in my listing earlier. But there's no question in my mind that the standard under serious medical condition definition is that COVID related conditions could clearly fall as an FML qualifying event. And so you've got to be careful of that. And Steve, I think that goes back to your point about what counts and what doesn't count toward incentive payments as well. If employees are submitting the proper paperwork and having it qualified as FML, serious medical condition, then it's going to affect not only the use of the leave at that point in time, it's going to give them added protections under the FMLA, and then also have some potential trickle down inside the union contract itself. I've not seen any specific requests that any client has brought to me yet on serious medical condition under FMLA, but it's in all the literature that I'm following, and there are cases that have been cited on it, but most people are just understanding that if it meets the criteria, they're treating it like FML. So HR professionals out there have, in my opinion, done a really good job. They're not raising a lot of issues that don't need to be confronted at this time. So I just want to do a couple of follow-up points, Don.
Okay. I do have a couple questions. One is we have a group of individuals who represent various organizations in the audiences. We have an arbitrator or two, and I'm kind of curious to hear from them. What are your experiences? What are they doing in your agency? Do people have to come in and work, and do they, or does you let them stay at home, or how's that all get handled? And I see we got a question here. Won't most any contract provision of addressing COVID be belated at this point? Simply, we're moving from a pandemic to an endemic, always with us. What are your thoughts on that? We're talking about, the question is, it seems to be if we have a contract provision, we're addressing a pandemic, but now since it seems like it's always going to be with us. What are any ideas or thoughts on that question? I mean, in other words, are we addressing something that it's going to be with us all the time? Does that make sense?
Well, I mean, I think, yeah, it's broader than just COVID. I mean, I don't think the contract language that we would be looking at would use terms like quarantine and things of that nature as opposed to COVID directly. But it's just raised a lot of issues about taking leave when you're not sick, having requirements when you don't feel like there's anything wrong with you. And it's, I think that there are ways to add some language to contracts that would address this. For instance, there's some provisions in a lot of contracts that say that if you are on vacation and you're hospitalized, then you can convert that vacation to sick leave. Well, what about if I get COVID when I'm on vacation and I don't have to be hospitalized, but I've got a positive COVID test? Should I not be able to convert that vacation time to sick leave for that? But technically, because I'm not hospitalized. So there's a lot of things that I think call for broader definitions than what we've seen in the past because of the experiences of COVID and what's taught us.
Okay.
Well, not surprisingly, Don, I'll take the opposite view. So the problem with saying what's a pandemic or not as a pandemic, and how granular can a definition be? What does the term emergency mean? What is the term declared by? Who's declaring by? And so we're going to have more pandemics. It's just a question of about when or what is going to happen. And we're going to see specific situations like what Steve has raised as an individual, understandably wanting to protect their leave balances on vacation or sick or where have you. And that's important. I thoroughly appreciate and understand the desire to protect my balance of leaves that I have of accrued payable leaves if I'm working in a position where that's accrued. The difficulty comes into where are the lines, where are the exceptions being made, and so forth. So if it's being negotiated, it's the same as any other issue that's being negotiated. How granular is the information? How granular is the definition? And that's an interesting negotiations issue, which brings about a lot of immediate reactions by supervisors, by managers, by elected officials, et cetera, because there's been a lot of money spent in a lot of places during this for a lot of reasons, and we'll see how that plays out on economics for the next 3 years. Because to me, downstream, looking at the macroeconomic is going to affect and impact us as well, because it's going to impact the tax base and where revenue is derived for public employers.
Okay. Any questions from the audience?
I do want to point out this, is it Mickey Riffle? Is that a Cincinnati Bengal behind you? I just want to make sure that I've got that.
It was, yes, it is, and I'm still a fan.
Well, we're proud of you. We're proud of the Bengals. Ohio likes their favorites, their hometown son too. Don, I don't know, in terms of the courts, what I've seen is the courts are moving gingerly in this area. The mandates for employees in certain areas, we know that was the one issue that was carved out. Steve mentioned his comments about mandated vaccines for people working in certain environments, as opposed to others where it was struck down. So we have a concern for the health and safety of people that we serve as well. I should say you serve, that the employees serve. And it's one of those social issues that's just going to take time. We're seeing the effect and impact in the schools. For those of you who work with school districts, the impact there. My daughter teaches in Virginia in Blacksburg, gifted children's program. She was doing hybrid teaching last year, which is also sort of the same thing. If the teachers can do it, why can't we do that in the workplace? Can we have a hybrid workforce? Well, that gets to your remote work question as well. Now, what works, what doesn't work? Is it an ADA question, as an accommodation, or what have you?
The question I have is, when these matters, not so much in court, because we're probably still working their way through it, but in terms of arbitration and grievances, as well as the unfair labor practice charges, what is the question that is being raised? What is the allegation being raised?
Steve?
So I think there's several. So at CERB and unfair labor practice, the issue is going to be whether the employer is required to negotiate to impasse, and then have the statutory impasse procedure apply, as opposed to effects bargaining, and then implementation of their whatever policy they have. In the arbitration context, sick leave is probably the biggest area where this has come up, because that's where the employees are being required to burn their sick leave. I think we've got, as I started to talk about a little bit, we've got an interesting case where employee has refused to be tested, and the policy says that if you refuse to be tested, then we're going to send you home on your accrued leaves. And that presents even another problem of, is that circumventing just cause protections for discipline? So we're seeing that. And I think you've got maybe some oddball cases. I've got a couple of them just based on some unique contract language about, this new form, no new forms of discipline, absent negotiation. And so, there's a couple other oddballs, but I would say that sick leave is probably the area where you're going to see most of the arbitrations on COVID.
I agree. And my consistent and pretty much adamant advice to clients since day one is talk, listen, put the issue on the table. It's one of the most fluid issues that I've seen in my 30+ year career. And if you don't talk, then you're gonna get in trouble somewhere. You're gonna get good reviews. You're gonna have unhappy campers. There's a lot of unhappy campers now, anyway, understandably, because of the pressures and the social issues, the home life issues, et cetera, et cetera, et cetera. It just layers one on top of the other. But employers are under an absolute obligation to discuss the effects of it. I think Steve's point of whether or not it's something that has to go to impasse, then it begs the question of, is it something that will wait till the next round of negotiations? So you put it on the table, and is it a mandatory topic, et cetera? So I'm not seeing a lot of that from arbitrations. I'm sorry, from fact findings yet. We've had one proposal advanced in a safety forces contract for additional leave time, which was denied in the fact finding in that situation. But otherwise, the clients that I work with directly are not agreeing to additional leave time. They're trying to work with employees if they have to be sent home. There are a couple of clients who have grievances on that. But in terms of impasse proceedings, I've only seen one case so far, and not even in negotiations. It's not coming up there as well.
At this stage of the game, a lot of folks have adjusted to virtual meetings, negotiations. You were talking about it earlier. What are you seeing now? Is it still the same? Things are virtual. People have adjusted to it. Hearings, are they in person? Are they virtual? What is it? I mean, my experience is, we have in-person hearings, and as long as we keep our distance and masks, everybody's got to wear a mask except the person talking. What are you seeing? What is your preference? Can you make some comments on that?
So I think Johnathan was, I think I agree that the preference is to have in-person hearings. There are certain people that have, some comfort level or discomfort with that. I've been fairly agreeable to work with either an arbitrator or opposing counsel on if they've got some strong feelings on not being together. But I do think there's going to be more and more push to actually have live hearings on a lot of these cases in the future. And it's just from the client who just doesn't, it's just not as you can't get the same feel from this as you do in person. So
negotiations as well, right?
I think so. I mean, as much as I do like the idea of being in my office, and negotiations always includes a significant amount of downtime. And if I could be sitting in my office and go back and work on something else for the hour and a half that I'm doing nothing, that's wonderful. But I think that something important is lost in that process. So I would see as things return to some level of normalcy, I would see more in-person negotiations and arbitrations. And we've got, there are some arbitrators that have actually taken the position that they're not going to do in-person hearings. They won't do them. And that's not something that I'm comfortable with, just to have a blanket, we're not doing in-person hearings. So, that's been a problem, I think, for some of my people. So, but I think I understand why there's been a reluctance over the last year plus, but I think that there's a desire to get back to live hearings.
Okay.
Don, Don, almost all of our negotiations, in fact, I can't think of one. And Steve, I think the last time I had a virtual negotiations was with you last fall. We've been back at the table live in negotiations. Yesterday, day before, I've had one, and I've got one tomorrow, the fact-finding hearing. Where the credibility and the presentation are important, we're back live. The only thing that we're actually doing now in remote are, still doing some federal court hearings remote, still doing some state court stuff remote, doing a few depots that way. Arbitrations, the only arbitration that I would probably entertain to be remote would be a contract interpretation. And then I need to know that the arbitrator is up to speed on being able to read documents on a computer screen, and that he has or she has at least two screens, one to look at the doc and so forth. So to me, we're going back to that. But what I'm also finding is the utilization of some of the electronic tools that we've learned how to use during this process. We meaning generally rather. Such as putting contract language up on the screen while we're working on, we're discussing, and so we're embracing more of the technology, which has been very, very helpful in that respect. So there's an upside to it, but I think, Don, basically 98% of it's going to be back at the table.
Okay, very good. I just to relate an experience, one of the first ones I had doing a virtual hearing. I had a witness, and the witness, was coming along, but she seemed to be a little bit distracted. And so finally I had to ask the question, who else is in the room with you? And in front of her was, like her husband or somebody who was I thought was writing down the answers to give to her. But in any event, so you want to know who's in the room when you have a virtual hearing. So
there's certain protocol that must be addressed regardless of the nature of the remote meeting. If it's a virtual meeting with clients, if it's a virtual meeting with an arbitrator and a witness, there's certain protocol. And that's a good point, Don. For instance, we had with Steve, we had very specific ground rules about being involved in negotiations virtually. One was your camera's on, your mic's off, and nobody else is in the room. No smoking. You can drink and eat, but there's no smoking on camera. And even though sometimes the cameras came back on, it was a little hazy in some of those rooms. There's certain protocol that must be followed there for the efficacy of the process.
Okay. We have Betty Rankin is raised her hand.
I did.
Betty Widgeon, excuse me, sorry.
That's all right. I saw another person on the screen with the Rankin name, and that's my maiden name. So I was wondering about that. But I have a couple of questions. Steve, I had an early question for you, and you were talking about when the members at both extremes try to push you about your feeling regarding the vaccine mandate, and you say, I just don't have any comment on that, or I don't have an opinion. Do they ever try to push you and say, well, have you been vaccinated? And if so, how do you respond to that?
I say it's none of your business.
Okay, that's a good
answer.
answer.
I mean, I just, the problem I have is, I'm in a no-win situation on this, and it's frustrating for, I think frustrating for everybody, that this issue has become what it has become. But realistically, there are people that are extremely vocal on both sides of this issue, and it would not serve my interest as a person who represents over 100 different police and fire unions to put myself in the middle of this issue. Just doesn't make sense. So I just stay out of it.
Right. Sounds like a really good answer. And I was looking at some of the stuff that we were talking about just recently. Johnathan, I think you were talking about maybe the protocols when people are virtual. Mm-hmm. A lot of arbitrators that I've spoken with would love to have the situation where it was a hybrid. Have either of you dealt with that where the arbitrator is remote and because of some of the things like you raised, parties not necessarily trusting that the other side is not going to coach, that the parties, if they're comfortable, are in the same rooms, but the arbitrator has more flexibility with her schedule, say, to come in there today, to be somewhere else tomorrow, to be on the West Coast the day after that. Have you done much with that, and what's your feeling about it?
Well, the answer is yes, and I like it.
Okay.
If I have the opportunity to confront the witness and the arrangements are sufficient, a good camera, good microphone, the logistics work, I'm in favor of it. I would not have any particular issue with a discipline, except maybe a termination or something that's somewhat egregious in the fact pattern. But clearly in a contract interpretation case, we can't tell what you're thinking anyway, because every arbitrator is practicing poker as well. So I think it's a great idea, Judge. I think it's a marvelous idea to bring it in. Then it gets to the comfort level of the parties. I can explain to my clients that this will work, and because now Steve representing employees, an employee may feel uncomfortable with it, and I will defer if Steve tells me that he doesn't want to do it for whatever reason. That's none of my business. Fine, but I'd be delighted with it. One caution that I would give you, though, is even though you're picking up a day that you don't have to travel somewhere, what I have found is the most difficult part for me with virtual meetings is too many.
Right.
I stack them up more, which means my evenings are working on whatever as opposed to enjoying a bourbon and a good book. But so that would be my only caution. Also, I think we could do extended hours. I mean, we don't have to worry about the travel time, and it's local breaks and so forth. So I'm in favor of the judge being remotely arbitrator. I would favor that, and I would defer to Steve if someone on his side is uncomfortable with it.
Anything different, Steve?
Yeah, I think that my sense is that people want everyone to be there live if that is possible. And I understand exactly what you're saying, and I have enjoyed the ability to have a meeting, with sheriff's employees in Cuyahoga County, and the same day having a meeting with some of the Hamilton County Sheriff's employees, right? And back to back, it's like, how can I do that? And I didn't have to drive 10 hours to accomplish that. So I get it, and I think it is wonderful, but I do think something is lost even on the arbitrator who's not there to get a sense of kind of what a feeling that I think you are going to get from people without necessarily what they're saying. And so I understand it. It's not a bad idea, but I think that a lot of employees are going to feel like they're not getting their day in court with that process.
Right. Don, if I could just say one other thing about what I've seen here in Michigan, and that's just that, for a while there, I would say my cases, I had maybe 75 or 80% of them that were virtual, and now it started to move back the other way or toward the center. But I would doubt that it's going to get much less than the 50-50 ratio, because I've had lots of people who are requesting that now here locally in Michigan, which is somewhat of a surprise. Also, I'll say that, Steve, usually it is the union who is objecting to a virtual hearing, but I've also had cases where they tell me right up front that this union is not doing any more cases in person until further notice. So when that happens, the management generally doesn't have any problem with it either, and we do it virtually. Those aren't all in Michigan. Some are, you can do them nationally now, which is a good thing for arbitrators. But thank you.
Okay, thank you, Betty. Thank you. All right, is that generating any other questions, discussion from anybody, our other participants? All right, I'm not seeing any hands raised or any comments in the chat box. With-
Felicia has her hand up.
I'm sorry,
Felicia Bernardini.
I'm not going to see it. Let me go to her. Okay, Felicia. floor is yours.
Yes. Hi, thank you for taking my comment. I just wanted to say that I have been doing live arbitration cases all through the pandemic, except for the short period of time where everybody was shut down and nobody was doing arbitration cases then. And I would agree with the speakers that we haven't really had any problem. And one of the reasons why I think it's important to continue to do live and in-person hearings is quite simply because the people we're serving are live and in person in the workplace. You know, very few people that are in a unionized work environment, whether it's in industry or in public sector, have been off and working remotely. I mean, there's a lot of people that are working remotely, don't misunderstand me, but in terms of the unionized workforce, most of them have been back to work since the initial shutdowns. And for me, it's just a matter of respecting the fact that they're going into work every day and learning how to cope with this. And I feel that in my service to them as a neutral, that's one of the things that I can do. And I don't have any health issues. I don't have any problems that I have to be particularly concerned about. So I'm perfectly comfortable going into the workplace. And I have been pleasantly surprised at how receptive everybody is to continuing to do for, you know, in-person hearings. And that's all I wanted to comment on. When the people are in the workplace, I'm happy to go to them to do my hearings. So that's it. Just another perspective.
Thank you. Thank you. Well, it certainly seems like that, you know, in-person hearings that's coming back. So, all righty. Anyone else? Any other comments, questions?
Don, I would just want to wrap up by saying, you know, we've been through a pandemic. We are seeing something in the economics that is unparalleled in the history of modern economics. We have the great quit. We have a need for productivity. We have the need for more workers. We have the impact, especially in Steve's world, and fire and police, due to, you know, change in the workforce. So if you look at the demographics, you look at the macroeconomics, everybody on this call, we are all in the middle of a very dynamic situation. And I think I want to continue to work toward what are good positive aspects out of this. What have we learned? How do we build on this? How do we move forward with it? How do we adequately compensate employees? How do people produce or serve in the issue? Because in the public sector, it's different. We don't measure productivity in the number of widgets or in the oil wells drilled or what have you. So we have a really particular challenge, and I'm excited about it because there's a lot of things going on. But we're also extremely challenged by the effects and the impact that we deal with. So I want to look at this as a bucket half full, and I think that you know, we need to keep looking at this and moving forward. We're going to see a lot of innovations come out of this, a lot of good ideas come out of this, but we're going to have to struggle through the changes. The people who are adversely affected by COVID, the long COVID, the family issues. So there's a lot of impact to a lot of people, and that's, I'm not degrading that one at all, but we have to pay special attention to those things as well. But I just want to ask people, keep your eyes on the horizon. Let's look out there and see how we can build better on all of this.
We have a follow-up question, and that is, how are you dealing with people who have high anxiety or fear of returning to the workplace because of COVID?
I think
Anyone?
there's counseling necessary. I mean, kids are having that issue. I mean, how many of you have school kids out there? No, mine are my grandkids who are school kids, so you know their parents can address that. But it's the anxiety about going back to the workplace. The masks being dropped now by orders of the schools. There are a lot of kids out there and adults who have that particular issue and that anxiety. And I don't think this differs from any other types of anxieties that we've dealt with in the past. We just have a shortage of counselors in this area. So I think we're dealing with another application of standards and options that we have available now. I know Steve's had to deal with deaths. I mean, if you want to talk about effect and impact, members inside the safety forces are dying after exposed to COVID in all areas, you know, the corrections facilities, et cetera. So to me, Don, it's another issue. It would be the same as if they were coping with anxiety or depression brought upon by some other condition. Not to diminish it, but to say you're armed with the tools. Use them.
Good.
And
All
Don,
righty.
I'm
Go ahead,
sorry,
Steve.
I'm gonna have to jump off here. I've got another 1 o'clock speaking engagement. I apologize, but I kind of committed to this before we even set this up. So I appreciate you all allowing me to be involved. Thank you, Don and Johnathan, and I will listen to whatever else happens afterwards from the recording. But thank you very much for having me.
Thank you, Steve. Appreciate
All
your
right.
comments.
Thanks.
Thanks. All righty. I don't see any other questions out there. With that, I also want to thank you, Johnathan, for your comments and your observations, and are always welcome. With that, we're going to end today's meeting, our virtual meeting, and I want to thank everybody for showing up. I can't tell you who our next speaker is, because I don't know, but I'm sure someone you'll get a notice on that as well. I also want to mention we have our arbitration, one of our arbitration courses coming up this Friday. Please pay attention to that. I have been pleasantly surprised with how successful those have been, the topics and the speakers on that. So if you haven't taken advantage of that, please catch what you can, because it's been, to me, it's been a treat. It's been done well. So with that, I want to thank everybody, and you now have permission to leave. So we'll talk to you all later. Thank you.
Thank you, Don.
Bye-bye.